Hi students, welcome to lesson 27, Constitution, Law and Social Change. Social change incorporates significant modifications in the various patterns of the social relationships, social processes, social actions, interactions, norms, values, symbols and cultural products. The concept of social change includes variations over time in both material and non-material aspects of the culture. These changes can be due to endogenous and exogenous forces which imply internal and external forces respectively. Several factors and agencies contribute to social change. Constitution and law are significant agencies of social change, especially in modern industrialized societies. After completion of this lesson, you will be able to understand the role of Constitution in bringing social change. You will be able to explain the relationship between law and social change. Now let us discuss about Constitution and social change. The dominion status came to an end and India became a virtual sovereign state with the adoption of Indian Constitution on 26 January 1950. The Constitution of a country is a document which consists of broad framework of fundamental principles according to which the country is governed. The preamble to the Constitution of India is a brief introductory statement which comprises of guiding principles of the document. The preamble states that India is a sovereign, socialist, secular, democratic republic. The word socialist and secular were added in 1976 through the 42nd Constitutional Amendment Act. The ideals of Indian Constitution are justice, liberty, equality and fraternity. The fundamental rights, directive principles of state policy and fundamental duties are the sections of the Constitution of India that prescribe the fundamental obligations of the state to its citizens and the duties of the citizens to the state. These ideals and sections of Constitution has been instrumental in inspiring various legislations and policies which were instrumental in bringing social change. India's adherence to democratic socialism witnessed the introduction of development planning and nationalization of banks and heavy industries. Several measures of social change were introduced through socialistic measures to end poverty, ignorance, disease, gender inequality, especially in wages, insecurity of the elderly, 𝗧𝗦𝗔𝗧, destitute, orphans, widow, exploitation of the working class, etc. Land reforms were introduced through abolition of zamindari system, abolition of intermediaries, tenancy reforms, ceiling on land holdings, consolidation and cooperative farming, etc. The Constitution of India accords secular state which ensures same status to all religions in the country, and the state is prohibited to make discrimination on the grounds of religion, caste, etc. India is a democratic republic. Universal adult suffrage has been introduced and any Indian who completes the age of 18 is a citizen or elector without any discrimination other than that are prescribed by law. Therefore, Indian women got the right to vote and contest elections immediately with the adoption of the Constitution, which was a long struggle for the women in other parts of the world. The Constitution provides for electoral parliamentary democracy, that is, the rule of law and majority rule. The 73rd and 74th Constitution Amendment Acts in 1992 have introduced local self-government in rural and urban areas, which facilitate three-tier government in the country. Local self-governance has proved to be a significant source of social change at the grassroots level. The constitutional ideals and values such as liberty, justice and equality have widespread social implications. The Constitution has guaranteed to all the citizens a set of fundamental rights. Defined in Part 3 of the Constitution, fundamental rights apply irrespective of race, place of birth, religion, caste, creed or gender. Rights are not only given but also protected by the courts. Right to equality in Article 14 to 18, right to freedom in Article 19 to 22, right against exploitation between Articles 23 and 24, right to freedom of religion between Articles 25 to 28, cultural and educational rights in Article 29 and 30, right to constitutional remedies in Article 32, right to have compulsory primary education, which was included in 2002, as part of which 6 to 14 years to be provided free and compulsory education. Untouchability has been declared as a punishable crime, thus bringing out major social transformation. Hindu temples of a public character are open to all classes and sections of Hindus as per Article 25, Clause 2, Subclause B of the Indian Constitution. Minorities have been given protection by the state for their language, culture and education, etc. Traffic in human beings and forced labor have been declared unlawful and thus punishable. The system of reservation has been an instance of justice given to the marginalized or underprivileged sections of the Indian society. Receiving mandate from Article 37 to apply the directive principles in making laws, the government, that includes parliament, executive and judiciary, is trying to introduce new laws so that socio-economic justice could be provided to all the sections of the society. The right to work through Mahatma Gandhi National Rural Employment Guarantee Act, popularly known as NREGA in 2005, Right to Information Act 2005, etc. are some important acts of parliament that have wider social impact. The Scheduled Caste Tribe Commissions, Minority Commission and Women Commission are also some important institutions in that direction. The directive principles between Articles 36 to 51 of state policy, these are those guidelines for framing of laws by the government. They are the provisions set out in Part 4 of the Constitution, borrowed from Ireland, and they are not enforceable by the courts. Fundamental guidelines for governance that the state is expected to apply in framing and passing laws. State has been directed to strive to promote the welfare of the people by securing and protecting a social order in which justice shall inform all institutions of national life. These principles have been translated into laws in these years to bring about socio-economic change. Almost all the states have passed land reform laws to bring changes in the agrarian society and to improve the conditions of the rural masses. The Minimum Wages Act 1948, the Contract Labour Regulation and Abolition Act 1970, the Child Labour Prohibition and Regulation Act 1986, the Bonded Labour System Abolition Act 1976, the Trade Unions Act 1926 amended in 2017, the Mines Act 1952, the Factories Act 1948, the Maternity Benefit Act 1961, the Equal Remuneration Act 1976 are few of such exemplary acts to herald social change. Presently, the Indian Constitution has 470 articles in 25 parts, 12 schedules, 5 appendices and 104 amendments, with the last amendment on 25th January 2020. Several amendments of the Constitution also have initiated reforms and brought revolution in the society. The first one in 1951 placed the zamindari abolition laws beyond challenge before the courts of law and inserted Article 31A for the purpose. It also amended Article 15 in the interest of the educationally and economically backward classes. In a similar way, the other amendments have been brought to bring social revolution in the country. The Constitution 103rd Amendment Act 2019 brought changes in two constitutional freedoms, Article 15 and Article 16. It makes provision for advancing the economically weaker sections of society. A significant 10% of all government positions and college seats will also have a quota. This bill is drafted with a commitment to enforce Article 46 of India's Constitution, a directive principle which urges the government to protect the educational and economic interests of the weaker sections of the society. The role of judiciary has been remarkable in the direction of social change and justice dispensing. The public interest litigation or the social interest litigation have revolutionized the judicial system. It is quick and not so formal system of grievance hearing and giving justice. The apex court sometimes considers such cases suo motu, that is, relating to an action taken by a court of its own accord without any request by the parties involved. However, this sort of judicial activism has received a mixed response. For many, the judiciary is seen as the savior of the voiceless or the weak. Some others criticize it as interference in others' domain. Despite the explicit mention of separation of power, the three branches of the government, legislature, executive and judiciary, exhibit coordination. Indian Constitution has shown its adaptability and dynamism. However, some have criticized it as too much flexible, unlike any other federal state. They have therefore suggested for the rewriting or revision of the Constitution of India. In response to that, even a national commission to review the working of the Constitution under the chairmanship of Mr. Justice M.N. Venkatachalaya was established in February 2000. The terms of reference stated that the Commission shall examine in the light of the experience of the past 50 years as how best the Constitution can respond to the changing needs of the efficient, smooth and effective system of governance and socio-economic development of modern India within the framework of parliamentary democracy, and to recommend changes, if any, that are required in the provisions of the Constitution without interfering with its basic structure or basic features. Now let us discuss about law and social change. Law is determined by the sense of justice and the moral sentiments of the population, and the legislation can only achieve results by staying relatively close to the prevailing social norms. Law is a vehicle through which a programmed social evolution can be brought about. Laws are forms of social change emanating from political agencies. They are directed towards social change. Social legislations can be an effective means of social change only when the existing social norm is given a legal sanction. Unaided social legislation can hardly bring about social change. law must bring about social change by influencing people's behavior, beliefs and values. A number of social legislations were made in India with a view to bring about visible social change. For instance, the Hindu Marriage Act 1955 enforced monogamy and permitted judicial separation and divorce. The Hindu Succession Act of 1956 gave absolute rights over property possessed by a Hindu woman. The Untouchability Offences Act 1955 made any atrocity against Dalit an offence. Sometimes laws can bring indirect social changes also. For example, laws regarding social security of women would have an indirect effect on marriage age and family structure. Law is an important formal means of social change. Legal regulations either may or may not conform to the pattern of society. If the law does not conform to society, it faces opposition. But if the law is stringently upheld, it induces a change in social organization. For example, child marriages have been a customary practice in many communities in India. But after the introduction of Child Marriage Restraint Act 1929 and in post-independent India, Prohibition of Child Marriage Act 2006, which came into force on 1st November 2007, child marriages have reduced, and the same happened with sati system, now almost unheard of in India after the introduction of Sati Prevention Act 1987. The law relating to marriages, widow remarriages, girls' share in property, right to information, etc. has changed society to a great extent. As an instrument of social change, law involves two interrelated processes: the institutionalization and the internalization of patterns of behavior. Institutionalization of a pattern of behavior refers to establishment of a norm with provisions for its enforcement. Internalization of a pattern of behavior means incorporation of the value or values implicit in a law. The extent to which law can provide an effective impetus for social change varies according to the conditions present in a particular situation. It has been proven that law is likely to be successful to induce change if it meets these 7 conditions. Firstly, law must emanate from an authoritative and prestigious source. Secondly, law must introduce its rationale in terms that are understandable and compatible with existing values. Third, advocates of the change should make reference to other communities or countries with which the population identifies and where the law is already in effect. Fourth, enforcement of the law must be aimed at making the change in a relatively short time. Fifth, those enforcing the law must themselves be very much committed to the change intended by the law. Sixth, the instrumentation of the law should include positive as well as negative sanctions. Seventh, the enforcement of the law should be reasonable, not only in the sanctions used but also in the protection of the rights of those who stand to lose by violation. The advantages of law as an instrument of social change is attributed to the fact that law in society is seen as legitimate, more or less rational, authoritative, institutionalized, generally not disruptive, and backed by mechanisms of enforcement. A principal benefit of law as an instrument of social change is the general sentiment in society that legal commands or prohibitions have to be observed even by those critical of the law in question. To a great extent, this emotion of obligation depends on respect for legitimate authority and the perception of power. In this context, it is indeed very interesting to note Max Weber's contribution on legitimate authority. He says that there are three types of legitimate authority: traditional, charismatic and rational. The traditional authority bases its claims to legitimacy on an established belief in the sanctity of traditions and the legitimacy of the status of those exercising authority. For example, rule of elders. Charismatic authority bases its claim to legitimacy on devotion to the specific and usual sanctity, heroism or enigmatic persona of an individual. The charismatic leader is obeyed by virtue of the personal trust in his or her revelation or exemplary qualities. For example, Mahatma Gandhi. Rational legal authority bases its claims to legitimacy on a belief in the legality of normative rules. In such authority, obedience is owed to a legally established impersonal order. Rational people voluntarily make a contract that generates the impersonal legal order. Law is binding because most people in society consider it to be. Some consider the content of the law to command obedience, which in turn is seen as a compelling obligation. Even when laws are against accepted morality, they are often obeyed. Under certain conditions, many people violate their own moral norms and inflict pain on other human beings, and succinctly underlines the notion that most people willingly submit to authority and by extension the law. Sanctions for disobedience to the laws are surely among the primary reasons that laws are abided. Sanctions are related to legal efficacy and are provided to guarantee the observance and execution of legal mandated to enforce behavior. There are, however, certain limitations of law in creating social change. To most people, law is imposed externally in an almost coercive way. Few people participate in the formulation of laws and legislation. One of the limitations of law as an instrument of social change is the possibility of prevailing conflict of interest. Other limitations related to the efficacy of law in social change include divergent views on law and the prevailing morality and values. The scarcity of resources causes conflicting interests. The renowned philosophers and social thinkers Karl Marx and Max Weber said that many laws are created to protect special economic interests. This is because economic interests are strong factors influencing the creation of laws. Weber recognized that besides economic interests, law protects other interests too, such as personal security, personal honor, and it guarantees political, religious and other positions of authority and social prominence. The mechanisms of change through law include large segments of the population. Even in democratic countries, the large scale participation of citizens in social change is not feasible. However, the lack of participation doesn't mean lack of representation. Let us now discuss law as a policy instrument. Law by itself cannot bring directed social change, but it is one component of many policy instruments that must be used in combination. The difference between law and policy is that law is a final decision or a document made by the government after discussing the policy for the welfare of society. The policy is an outline of governmental plans. For instance, in the case of social problems like drug abuse, race relations, law can be used effectively as a policy instrument. But sometimes, in order to bring change, law should be an ingredient of a larger policy. Usually, law is used as an instrument of social change outside of a broader policy framework, but broader issues concerning environmental or natural resource management issues should be reformed using broader policy making frameworks. The cause and effect relationship between law and change is very difficult to identify because the ability of the law to produce change is contingent and sequential. Even though some changes can occur, other factors such as the morality and values of society affect the efficacy and time lag of laws in causing change. 𝗬𝗏 British sociologist, suggests that laws should deal only with the acts that can be precisely defined and with external observable acts, and the law should as far as possible respect privacy. Thus, laws most likely change external behavior which are consequently later on followed by changes in attitudes, values and morals. In contrast, William Graham Sumner, the American sociologist and economist, said that laws can regulate only behavior and not values, morals and attitudes. On the other hand, this law that required change in behavior has gradually changed attitudes too. The law can change morality and values under specific conditions. Even though there are not enough empirical studies, it is accepted that the efficacy of law depends on its adaptation to morality and values if it aims change. Let us now discuss about resistance to change. In most cases, laws face resistance by members of society who find different reasons for their resistance, such as their values, customs or even the cost of change, and sometimes because people feel threatened by the change. Knowing the conditions of change helps in the implementation of laws. The factors that are a barrier to change are separated into social, psychological, cultural and economic factors, and all are interrelated and interdependent. Social factors like vested interests and benefits, ideological resistance and organized opposition resist changes in laws. Individuals resist changes in laws which are in opposition to their respective ideologies. For instance, laws connected with euthanasia, abortion, certain cultural festivals and rituals witness resistance. Sometimes individual resistance to change can be organized and channeled into a social movement or lobbyists. For instance, the recent farm laws in India have been resisted by certain farmer unions. Psychological factors like habits, motivation, ignorance, prejudice, selective perception also leads to resistance. Even though law is intended to be universal, the perception of people on law is selective and varies with economic, cultural and demographic variables, and also with attitudes, needs and values of people. A change is accepted easily if it is related to the interests of people and supports their values. The laws should be formulated clearly so that there is no misunderstanding by people. The cultural factors like ethnocentrism, incompatibility and superstitions impact change. The ethnic superiority causes ignorance towards others' ideas and methods and resistance to change. The incompatibility between the law, change and the target population is a major factor of change. Changes are resisted since it is human enacted and not from divine origin. Usually, economic factors are decisive in affecting resistance to change. No matter how much somebody wants something, if economic sacrifice is too great or they can't afford it, change does not occur. Change through law is very costly because of the instrumentation of legislation, administrative ruling or court decisions that are all costly. The distribution of costs and benefits also affects resistance. If they are equally distributed, there is little resistance, but if benefits are low and costs are concentrated, resistance is high. It has been argued that law in itself cannot lead to change. It cannot be the sole instrument of basic transformation of values and attitudes in any society. Social legislation is an important enabling mechanism of bringing social change. Law can be effective as a means of social change only if it is supplemented and supported by public opinion and administrative reforms. Friends, let us now summarize this lesson. Constitution and its inherent principles become significant factor in framing the laws of any country. With specific reference to India, the adoption of Constitution on 26 January 1950 paved the way for several welfare program, policies and laws to initiate and bring social change. Though law is a formal means and agency of both social control and social change, it operates in socio-cultural milieu and is inspired by it to a great extent.